Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm presiding judge here at County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felonies are normally referred to as your more serious type offenses, whereas your misdemeanors are referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, when I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is a minimum of 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, the case that you have in this court is a misdemeanor case, so you don't have to worry about those type punishments. Misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. You only could be given a fine. You cannot be given jail time. And the fine cannot exceed $500. Now, those Class C misdemeanors are cases that start in the city court or the JP court. For example, a traffic ticket, Class C misdemeanors. Not wearing your seatbelt, Class C misdemeanor. Having an expired sticker on your vehicle, Class C misdemeanors. Now, those cases come to this court when you are found guilty in one of those courts and you appeal your case. And that's what you like to have a higher court to give you a whole new trial. When it comes here, give you a whole new trial. The range of punishment is the same. It's still maximum $500 fine. You cannot be given jail time. Now, however, if you fail to pay the fine, or if the fine is converted to community service and you fail to perform the community service, then the court can issue what is called a capias pro fine. What that means is it's a warrant for your arrest to either pay the fine or sit the fine out in jail. And you receive $100 credit for every day that you sit in jail on your fine. All right. Now, the next highest misdemeanor is a Class B misdemeanor. With a Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, the highest misdemeanor is a Class A misdemeanor. And the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days in the county jail, which is 1 year, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation, and the other type of probation is called adjudicated probation. So you have unadjudicated probation and adjudicated probation. Unadjudicated probation, we normally refer to as deferred adjudication. With that type of probation, you don't have a conviction on your record. And if you successfully complete the probation, your case will be dismissed, and you may qualify for a non-disclosure. Non-disclosure is where your record is sealed to the general public. Now, the next type of probation, now when I say it's sealed to the general public, that simply means that the general public cannot have access to it. Does not mean that the government cannot have access to it. All right. Now, the next type of probation is called adjudicated probation. With adjudicated probation, you do have a conviction on your record. However, there's something that is called judicial clemency, which means that the court or the judge can set your conviction aside. You will no longer have this conviction on your record. But in order to qualify for judicial clemency, three things has to happen. One, you have to successfully complete the probation. Two, there cannot be any more time left on the probation. And three, you have to be successfully discharged or let off the probation by the probation department. If those three things happen, then the court has the discretion. That means that the court can set aside your conviction, and you will no longer have a conviction on your record. Now, however, if you get another conviction later on, okay, the whole new case later on, then the case that you received judicial clemency on can be resurrected. It can be brought back up and used against you. And if you try to get a license with CPS, that's Child Protective Services, they can deny giving you a license. If you have a license, they can suspend or revoke the license that you have. All right. Now, everyone here for a case today should have a clipboard. I'm going to go over the paperwork with you on that clipboard. Okay. The first document that you should have is should be titled Judge's Explanation of Rights to Defendants Without Attorney. That's the first document that we're going to go over. Now, everyone is going to read and sign that document. Now, the document states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. That is, the court can give you an attorney to represent you. And number three, you may represent yourself. That is, you can waive your right to have an attorney, which means to give up your right to have an attorney, and you can represent yourself and act as your own attorney. Now, the first paragraph below number three states that if you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means you will be given another court date from today's date to give you time to hire an attorney. The next paragraph below that says that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire. Now, the financial questionnaire is another document that is on the clipboard, and that document is titled, it's a 3-page document, and it's titled Jefferson County Affidavit of Indigence. The document looks like this. Okay? Jefferson County Affidavit of Indigence. Okay? Now, you would have to fill out the first page of that document. And then on the second page, go to the second page. You will fill out the top portion that is titled Defender's Oath. And you will fill out the middle portion that is titled Unsworn Declaration by Defendant. Okay, which is right here. So on the second page, you fill out the top portion, this little section here. And then at the middle of this document says unsworn declaration. You'll fill out that portion, okay? That's only for individuals who will be applying for a court-appointed attorney. Okay, now let's go back to that first document, judge's explanation. The next paragraph says that you may not talk to the prosecutors unless you first sign a written waiver of your right to have an attorney. What that paragraph is talking about is for individuals who would like to represent themselves. They'll have an opportunity to talk to one of the three prosecutors. Prosecutors are assistant criminal district attorneys who works for the Jefferson County District Attorney's Office. And the reason why you will have an opportunity to talk to them is because you are representing yourself. You are your own lawyer. Just like your lawyer will be able to talk to them. Since you're your own lawyer, you can talk to them. But before you can do that, you must first sign a written waiver of your right to have an attorney. Now, the written waiver is another document that is on the clipboard. It's a one-page document, looks like this, and it's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding Trial. Okay, you have to read and sign this document. So to make it simple, I'll just do a simple recap. If you would like to hire your own attorney, this is the only document that you're going to read and sign. This is the only one. Those other ones, you don't have to do it. And if you're going to hire your own attorney, you read this document, and then you'll sign it. Now, for those individuals who will be representing themselves, this paragraph right here in block, that states that you should be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you, including your case, including the loss of significant rights and opportunities related to military service, possession of firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time. For example, let's say you choose to represent yourself. You fill out the paperwork and you talk to one of the prosecutors, and you decided after talking to them that, hey, I want to represent myself, I want a lawyer. You can do that. Okay, you can change your mind at any time. Now, at the bottom of this document, it says defendant's choice. Mark initials next to only one choice. All right, this document right here, everyone should be looking at this document because you're going to make one of three choices. If you would like to hire your own attorney, then you will place your initials on the first line to the left. Okay? If you like to hire your own attorney, and this is the only document that I mentioned that you're going to sign. This is the only document. You're going to place your initials on this first line, sign it, date it, and it's over. And you don't have to worry about anything else. All right. For those individuals who would like to apply for a court-appointed attorney, you will place your initials on the third line on this document. Okay? You place your initials on the third line, and then you'll sign it and date it. And then you'd have to fill out this document that's titled Jefferson County Affidavit of Injuries. You'll fill out the first page. It's a 3-page document, only a document that has 3 pages. You fill out the first page, And then when we get to the second page, you will fill out the top of the first page where it says defendant's oath. And then the middle portion that it says unsworn declaration by defendant, and then you will stop. All right. Now, for those individuals who will be giving up their right or waiving their right to have an attorney, then you will have to put your initials on the fifth line to the left. Okay? Signed and dated, and then you would have to read and sign the document that is titled Jefferson County, that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Okay? So these are only two documents you would have to sign if you are waiving your right to an attorney. If you are applying for a court-appointed attorney, you will sign judge explanation, third line, and the Jefferson County affidavit of indigence. If you are wanting to hire your own attorney, you just, this is all, you're only signing one document. Okay? Anybody have any questions? Yes. Okay, what do you want to do? You want to hire your own attorney? You want to apply for court-appointed attorney? Okay, you want to apply for court-appointed attorney? Place your initials on the third line to the left at the bottom. The third line. Count 1, 2, 3, 4, 5 is the third line. And then you're going to sign and date. Then you will fill out the affidavit of indigence, asking for your financial information. It's a 3-page document. You're going to fill out the first page. Okay, the entire first page. And then you go to the second page. You're going to fill out the top portion where it says defendant's oath. And then you're going to fill out the middle portion that is titled unsworn declaration by the defendant, and you stop. Okay, anybody else have any questions? Okay. Okay, now we're going to give you an opportunity to fill out that paperwork a little later. I need to go over some more rights that you have. First of all, mention that you had a right to have an attorney. You also have a right to have a jury trial. For those young men are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. And they will listen to all of the evidence. You have a trial, listen to the arguments of the lawyers. They will go in the back in the jury room and deliberate. And then they will decide whether or not you're not guilty or guilty of the charge. All right. You also have a right to waive your right to have a jury trial, which means you have a right to give up your right to have a jury. That is, if you don't want to have a jury trial, you can waive or give up your right to have a jury trial. Now, your case can come before the judge by way of a bench trial. What a bench trial is a trial without a jury. It's a trial by judge only, where the judge is the judge and the jury in the case. The judge will listen to all of the evidence, listen to the arguments, apply the facts to the law, and decide to find you either not guilty or guilty of your choices. Now, if you decide you didn't want a trial, you didn't want a jury trial, you didn't want a trial by judge, but you wanted to enter a plea of guilty or no contest, now, I'll explain to you the different pleas. You can enter a plea of not guilty. And not guilty, you're telling the court that you did not commit the offense that you've been charged with. Enter a plea of not guilty, you want either jury trial or bench trial. Or you can enter a plea of guilty. Guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. No contest means you're not contesting or you're not fighting the charges. If you enter a plea of guilty or no contest, you're telling the court that you want to dispose of your case by way of a plea bargain. Okay? Now, Your case will come before the court by way of a either agreed plea bargain or unagreed plea bargain. I explain that to you. What an agreed plea bargain is, it's an agreement that you made with the state, the district attorney's office, to settle your case. You come to an agreement. Let's say, for example, the district attorney is offering you 6 months probation. And you say, I want 6 months deferred probation, okay, or unadjudicated probation. And it comes before the court, that's an agreement, y'all have an agreement. It comes before the judge can do one of two things. The judge can accept that agreement or reject that agreement. If the judge rejects your agreement, you have the right to take your plea back. In essence, you said, okay, I'll be entering to plead guilty. I want this plea bargain agreement. The judge don't want to follow it, then I take my plea guilty back. The judge says you're not following the agreement, I take my plea back. You have a right to do that. Now, the other type of plea bargain is called an unagreed plea bargain. What an unagreed plea bargain is that you and the state have talked, the lawyer talks to the state, they offer to settle your case for, let's say, 30 days in jail. And you say, well, I don't want 30 days in jail, but I still want to enter a plea. And so you'll come before the judge and the judge will decide what your punishment will be. We call that an unagreed plea bargain. You couldn't reach an agreement with them, but you want the judge to decide what the punishment will be in the case, okay? Now, also as a defendant, you have a right to have witnesses that come to court. The reason why I was looking back, there's a chair back there that has a microphone in front of it. We call that the witness stand. Okay, that's where witnesses testify in trial. And a witness, they can testify for you or against you. If you represent yourself, you can ask some questions. If you have an attorney representing you, your attorney can ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses. Waiving your right to have witnesses is saying that I'm not going to call any witness. I'm giving up my right to call witnesses. Now, just because you don't call witnesses does not mean that the state will not call witnesses, okay? They will call witnesses in your case. And you also have a Fifth Amendment right against self-incrimination. I'll explain that to you. The United States Constitution in the Fifth Amendment give you the right not to testify. Okay, I know sometimes we look at Law and Order and some of these shows on television. We see a guy on the witness stand and they want to ask some questions. He said, I take the fifth. Okay, that means I'm exercising my Fifth Amendment right against self-incrimination, and I'm not going to testify. The state, the government, the DA's office cannot force you to take the witness stand if you exercise your Fifth Amendment right against self-incrimination. Right? The state has the burden to prove you guilty. You don't have to get up there and prove yourself guilty. Okay? So you have a Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. That is, you can say, well, you know, I want to testify. You know, I didn't do nothing or whatever. I want to testify. You have a right to waive to give up your right, your Fifth Amendment right against self-incrimination. That's your choice. And that's your right that you have. All right. Now, you also have a right, you have a right to have what is called discovery. And what discovery means is you have a right to see the evidence that the state has against you. In essence, you have a right to discover what they have against you, right? You have a right to see your statements, witness statements, police reports, lab reports, photos, video recordings, listen to audio recordings, to see documents, instruments, whatever they have. You have a right to have access to them, to see why, you know, they're charging you with this offense and what they have to prove. All right. You also have a right to waive or give up the right to have discovery, which means that you're saying you don't want to see the evidence that the state, or have access to the evidence that the state will be using against you. Okay. Now, everyone that's here today, you hear You're out of jail. That is, you were arrested, charges was filed on you. You was in jail, you bonded out of jail. You're out of jail either on cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on surety bond, which means you pay a percentage of the bond to get out of jail. Or you are out of jail on a PRR bond or a personal recognizance bond, which means that you were released from jail without paying any money. You was released under your own personal recognizance with a promise to appear here in court. Now, the reason why I say that is because of this. Every day that you spent in jail, every day, it can be used as credit toward your punishment. The operative word that I used was every day. Okay? So, for example, let's say you were arrested and booked in jail at 11:59 p.m. on last night. And you booked out of jail 12:01 a.m. this morning, which is 2 minutes later. That's 2 days. Why is it 2 days? Because it's two different days. Okay? You was in jail 2 minutes, but you got 2 days credit. All right. So let's say you spent 5 days in jail. State is offering you 5 days in jail as a plea bargain. You don't have to spend any more time in jail because you'll be given credit for the time that you've already served. We call that credit for time served. Now, if the state is offering 7 days, you spend 5 days in jail, that means you would have to spend 2 days. Why? You already have 5, so we'll take 5 from 7 and leave 2. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. You receive $100 per day credit for every day that you spent in jail. So if you spent 5 days in jail, that's $500 credit that can be used toward your fine and court costs. So if the state is offering you fine and court costs of $500, you don't have to pay anything. Why? Because you already have enough. The $500, the 5 days you spent in jail is $500. So your fine and court costs will be taxed and retired. Now, if they're offering $700 fine and court costs, you spent 5 days in jail, which is $500. That means you only have to pay $200 because you already have $500. You take the $500 from the $700, that leaves $200. Now, you'll be required to pay the fine and court costs on the day that you dispose of the case. If you do not have the money to pay it, no problem. We can put you on what is called a payment plan, where you can pay off your fine and court costs in small monthly installments each month until it's paid off. Now, if you're unable to be placed on a payment plan because you do not have the income, no problem. Because we can convert your fine and court costs to community service. You will receive $12.50 for every 1 hour of community service. $12.50 will go toward the payment of your fine and court costs for every 1 hour of community service that you perform. So if you perform 8 hours of community service in 1 day, that's $100. That's going towards your fine and court costs. So in our scenario, you owe $200, 2 8-hour days. That's $200, and then it's over. All right. Now, Jefferson County has a program for first-time offenders. If you have never been in trouble before, Jefferson County, when I say Jefferson County, I'm talking about the district attorney's office, the DA's office. They have a program that is called pretrial diversion. With pretrial diversion, you get into the program, they will dismiss your case. And you complete the program, you can get it expunged from your record. Expunged means erased, deleted, wiped off from your record. Now, in order to qualify for the program, you have to have, it has to be your first time getting into trouble. You have to have an attorney to assist you with the application process. And it cannot be an offense for unlawful carrying a weapon or resisting arrest. If any other offense, you can be held. Now, if you're a veteran, of any one of the branches of the United States military, Jefferson County, the DA's office, has another program under the pretrial diversion program that is called Veterans Court. And with Veterans Court, it's for veterans only. What they will do, you get into the program and complete the program, they will dismiss your case. And you could get a non-disclosure. Non-disclosure is where your record is sealed to the general public. Okay, only criteria to get in that program is to be a veteran of any one of the branches of the United States military. That's the only criteria. All right. Now this court, County Court at Law Number 2, Jefferson County, Texas, has a program that is called the Community Safety Initiative. It's a program that God led me to start in the first 100 days of taking office in March of 2017. That program we refer to as the Community Safety Initiative, also known as the CSI program, is a program designed to address the issue of what we call recidivism. Recidivism is just a word that basically means people commit crimes over and over. And so how do we address that? Well, we address it through the Community Safety Initiative. And in the Community Safety Initiative, or the CSI program, we have partnerships with various agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop Center is our local mental health center in the Southeast Texas region. Spindletop has the expertise to address any mental health issues that you have. Now, basically, we have some folks here from Spindletop. They're going to come to you in a few minutes and tell you a little bit more about the program that they have to offer. And basically, what they would do today, they can conduct a private interview, either in our jury room, at their facility, by telephone, whichever is convenient for you. They can also do an assessment to determine what your mental health needs are. And they can develop a treatment plan for either outpatient or inpatient treatment. Now, you do not have to be incompetent or insane to participate in the program. You can just merely suffer from anxiety or depression or any other host of mental illnesses, and they have the expertise to address your mental health needs. If you have issues with drugs or alcohol, well, Spindletop has a program that is called ATAR. It's an acronym, ATAR, that stands for Addiction Treatment and Recovery. Along with that program that they have, we have a partnership with our local drug and alcohol counselor that has a program that is called OZAR. It's an acronym, OSAR, that stands for Outreach Screening Assessment and Referral. Both of those programs, a drug and alcohol recovery program. They can address any needs that you have regarding drugs and alcohol. And what they will do, they can do a screening, an assessment, and develop a treatment plan for either outpatient or inpatient treatment. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program, it's an acronym, it's called CICE. It stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas, they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school, you do not have your GED, they have a GED program where you can receive your graduate equivalency diploma. Now, all of these programs that I just mentioned, will not cost you anything, they're free. And like I say, they're free. Only thing it will cost you is time. And like I said, in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. We believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at Law Number 2, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individual that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. And we'll be happy to direct you to the individuals and we'll also be happy to give you brochures where you can make contact with individuals that can get you started in these programs. Now, as I mentioned to you earlier, we have some folks from Spindletop. They're going to come and tell you more about the program. And we also have a gentleman from Family Services who's going to come and tell you about the program that they have. Now, we have Gabby and Deputy Barry. They're going to come and tell you a little bit more about this program that Spindletop has to offer. I'm calling Gabby. I mean,
That's okay, Judge. That's okay. Good morning, ladies and gentlemen. My name is Patricia Berry, and I'm a deputy with Jefferson County Sheriff's Office. I am also a mental health liaison for the county. I've been doing that for approximately 7 years, and I have over 20 years of experience in law enforcement. My partner, Caitlin, is a qualified mental health professional with Spindletop Center. Now, like the judge said, the reason we're here is because he cares about each and every person that enters this courtroom. And statistics show that people who enter the criminal justice system oftentimes have mental health needs that are not being met, or substance use issues, or just simply a lack of resources. So that's what we're here today, is to help provide you with those resources. If you filled out the paperwork on that clipboard, you'll notice that the small piece of paper in the very front, that is a piece of paper that we placed on there. That is not mandatory. It is not mandated by the court. That piece of paper right there. That is simply for us to be able to contact you. And Ms. Caitlin here is going to explain to you briefly how to fill that piece of paper out. Again, if you do not choose to fill it out, you don't want to fill it out, you don't feel comfortable, you want to contact us at a later date, that's great. We'll take that as well.
At the top of the paper is basic information. It's your name, birthday, email, and phone number. We need those things to put you into our system and to be able to contact you. Underneath that is how we like to be contacted, and the options are call, text, and email. Whatever you check is how I will contact you. I will not contact you unless it's checked on one of those boxes. Underneath that is resources that you would like assistance with. And most of them is I email you some forms that you have to fill out yourself, or I send you a link or a website that you have to complete yourself. But if you were to check mental health, which could be depression, anxiety, PTSD, or substance use, which could be any type of drug or alcohol, then you'll work with Spindletop and we can get you the resources and the services and the support that you need. Everything else is pretty much self-explanatory. If you'd like to talk to me today in person about getting services or anything like that, then we just call you up and he's done with you. I'll come and get you and we can talk privately in the back room. Or if you prefer that I call you today, then just write, please call me today. If it doesn't matter when you want me to call you, then you can just check the box like normal and I'll get to you within a week.
We do understand that there is still a stigma that surrounds mental health. And we understand that you may not feel comfortable reaching out to us right now. If you do want to reach out, however you wish to do so, we want to make sure that you feel comfortable enough to come to us. Even if it is for somebody else, involving yourself. That's what we're here for. So in a few minutes, we're going to come around and we're going to pass out a small business card. And on the back of that business card is a crisis hotline number. It's a 1-800 number. It is 24 hours a day, 7 days a week. And it's available to you. If you have any questions at that time, please feel free to ask us. We're here to help you. And thank you very much for your time.
Thank you, Caitlin and Deputy Barry. At this time, we have Johnny with Family Services. He's going to tell you a little bit more about the program that Family Services has. So,
Judge, good morning. I'm Johnny Stewart. I'm with the name's Batteries Intervention and Prevention Program. I'm the director at Family Services. And if you have been charged with family violence, and it's your first time, there is another program offered, this program, but you have referred to the case. So one of the things is that we provide this service, it's 18 weeks to our groups. And we give you information and provide, you the tools you need to be nonviolent in your relationship. But family services also assists the victims or the family members, but they need counseling, outpatient, counseling and treatment. So it's twofold. It's not only to help you, it's also to help family members. So if, this particular program is something that you think we would help you and also help your family, please consider this, you get with the good attorney or either get with the, agent, attorneys here. And, this is something that, it's been very successful. We've been doing it for over 50 years. And I teach some of the programs. We have Zoom classes and we also have in-person classes. Matter of fact, we have one guy graduating last night. So this is something that you may want to consider if you've been charged with that. So I really appreciate your attention. So I'm gonna leave some of these right on the edge in case y'all need that. Okay, thank you very much.
Okay. Okay. Okay, ladies and gentlemen, we're going to be going into a break in a few minutes. And the reason why we're gonna go into a break is because we're gonna give you an opportunity to fill out the paperwork. We're going to pick up that paperwork from, if you need any assistance with filling out the paperwork, we have our court personnel who's here, who'll be happy to assist you. I'll be included. And so the only thing you have to do if you need some assistance with filling out the paperwork, just raise your hand and we'll come out and help you. And if you finish with the paperwork, just let us know and we'll pick that paperwork up from you. And then, once we pick up all the paperwork and evaluate it, we're gonna call you up before the bench, one at a time. And we're gonna put you in one of three categories. Either you wanna hire an attorney, you wanna apply for a court-appointed attorney, or you would like to represent yourself. And so, depending on what category you're in, your case is going to be handled in that manner. Okay, so now, this is gonna take us a little time to get through the paperwork and go through it. If you need to use the restroom, the restroom's right out in the hall. The female restroom is on the opposite side of the hall in front of the 172nd District Court. And the male restroom is on this side of the hall in front of the county court at law number 3. You will be allowed to go out into the hallways to use the restroom. Please do not leave the courthouse. If you leave the courthouse, your name is called, you're not here. Your bond can be forfeited. And if your bond is forfeited, a warrant can be issued for your arrest. Then you'll be arrested, brought to jail, and then we'll have to go through all of this all over again. Okay? So let's conduct ourselves accordingly. Even though we'll be in recess, even though we'll have a break during our recess, we're still in court. So conduct yourself accordingly. Okay? So at this time, the court will be in recess. Okay, Jefferson County Court at Law number 2 is back in session. When I call your name, please come before the bench by yourself, and this is the bench in front of the. You're gonna stand in front of the table that's in front of the bench. First case is cause number 25 CCCR 0724. Case is styled the state of Texas versus Kieran T. Green. Kieran T. Green, please come before the bench. Mr. Green, your full name is Kieran T. Green. Mr. Green, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Green? You doing good? That's good. Now, Mr. Green, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for, that you would like to have your case reset to hire your own attorney? Mr. Green, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Okay, Mr. Green, I read your answers. Your case is going to be reset by our court coordinator, but before she give you reset, I need to give you some bond conditions. Could you please step to the side and get these bond conditions? And you can step back. Okay, Mr. Green, I'm going to go over these bond conditions with you. And it states standard bond conditions in county court at law number 2. Following the return of a criminal information in county court at law number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3 and 4 does not apply, however, condition number 5 applies. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07, the penal code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Mr. Green, do you understand that condition?
Yes, sir.
Now, Mr. Green, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Please, please stand in front of the court coordinator. Ms. George, your full name is Brianna George? Brianna Deshay George? Ms. George, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. George, you may put your hand down. How are you doing, Ms. George? That's good. Now, Ms. George, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And there's, at the bottom of this document, there's a signature on a line that's titled Defendant. Is this your signature? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Ms. George, before you signed and initialed these documents, did you read the documents? Do you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Ms. George, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to leave. And you have a blessed day. Please have a seat in that first chair on the wall. Probably, was it municipal court or something? Well, that's some traffic tickets.
That's where I originally got stopped for, I guess. Well, I was.
Oh, yeah, okay, but there must have been, do you pay for the municipal city court? Okay, yeah, we don't. That's a different court from this one. Charges, let's see. Marquise O'Neill. Okay. Mr. O'Neill, your full name is Marquise T. O'Neill.
Yes,
So O'Neill, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. O'Neill, you may put your hand down. How are you doing, Mr. O'Neill? I'm doing fine, thanks for asking. Mr. O'Neill, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature online as titled defendant? Or are these your initials online that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled defendant signature. Is this your signature? Mr. O'Neill, before you sign and initial all of these documents that I just showed you, did you read the documents?
yes,
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. O'Neill, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. An attorney that will be appointed to represent you is Attorney Christy Cawthon. Attorney Cawthon will give information to contact you. You will also be given information to contact her. Our court coordinator will give you that information. Just have a seat and the bailiff will get that information to you. You can follow the bailiff. You have a blessed day. That's just it. Every time it comes on, it does that. Okay. Julio Garcia Hernandez. Mr. Garcia Hernandez, your full name is Julio Garcia Hernandez.
yes, sir.
Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing?
I'm good, how are you?
I'm doing fine, thanks for asking. Mr. Julio Garcia Hernandez, before we get started, you have a right to have a court reporter. That is someone to dictate or type down everything that's being said in this case. You also have a right to waive or give up right to have a court reporter. Do you waive or give up your right to have a court reporter?
No. We're thinking,
What do you want? Do you want a court reporter or not want one?
I'll wait.
Okay. Now, Mr. Garcia Hernandez, I have before me on my computer. Well, before I do that, I have before me on my computer a document, two documents on paper. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you want to waive your right to attorney and represent yourself?
Yes.
I also have another document that's titled Waiver of Counsel for purposes of the guilty plea proceeding in the trial. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Garcia Hernandez, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
And Mr. Garcia Hernandez, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Julio Garcia Hernandez, on or about June 20th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Garcia Hernandez, do you understand what you have been charged with?
Yes, sir.
To this charge, how do you plead? Guilty, not guilty, no contest?
No.
Now, you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means.
Yes, sir.
Now, Mr. Garcia Hernandez, I'm showing you a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials, or two sets of initials. The first set of initials is below a paragraph that's titled Waiver, and it's on a line next to a box that's checked. Nola contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
Second set of initials is below a paragraph that is titled Discovery Admonishment, and is next to a statement that reads, I do not wish to have discovery. I waive my right to discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials in this location? On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
Now, Mr. Garcia Hernandez, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct
Yes,
to
sir.
the best of your knowledge? Mr. Garcia Hernandez, are you a citizen of the United States?
No, sir.
You're not? Okay. And what country are you from?
Mexico.
Mexico. Okay, Mr. Let me do this here. Ms. Bailiff, could you hand this document to Mr. Garcia? Going to go over that document with you. Okay, Mr. Garcia Hernandez, the document that you have in your hand is titled English Statement Number 1 for all foreign nationals except those from the mandatory notification countries. And Mexico is not a mandatory notification country, so I will go over the top portion of this document with you. And it states, as a non-US citizen who is being arrested or detained, you may request we notify your country's consular officers here in the United States of your situation. You may also communicate with your consular officers. A consular officer may be able to help you obtain legal representation and may contact your family and visit you in detention, among other things. If you want us to notify your consular officers, you can request this notification now or at any time in the future. In the last statement, ask the question, do you want us to notify your consular officers at this time?
Yes, sir.
You do? Okay. If you do, you need to circle yes. In this case, we're gonna have to reset this case. Okay. Okay.
Print my name.
Yeah, you can print and signature. We need to have a witness. Could you witness it? Okay. Now, Mr. Garcia Hernandez, we're gonna reset his case. Okay, your case is gonna be reset. You'll be given another court date.
Okay.
You give us time to, I think she has to get some information from you. Hold on a minute. And again, you met the eligibility requirements for the Department of Court Appointed Attorney Charles Rojas. Now, Mr. Darden, you're gonna get a copy of these bond conditions and a copy of the reset from our coordinator. Once you get a copy, you're free to go and you have a blessed day. All right, you're welcome. Here you go. That's this. Rainy Prudom. Who's that? Miss Prudom. Your full name is Rainy D. Prudom? Rainy Deshae Prudom? Okay, Ms. Prudom, would you please raise your right hand? Ms. Prudom, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Ms. Prudom? I'm doing fine, thanks for asking. Now, Ms. Prudom, I have two documents before me. First document is titled Judge's Explanation of Rights to Defendant Without Attorney. You recognize this document? Is this your signature on the line? It's titled Defendant? And are these your initials online that states you'd like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And is this your signature on the line that is titled Defendant? Ms. Prudom, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Prudom, I read your answers based on your answers. Who did I point that guy to? Okay. I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that's appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you. You will give information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go. And you have a blessed day. Please have a seat in that chair and wait for your name to be called. Cheryl Getz. Ms. Getz, your full name is Cheryl A. Getz. Ms. Getz, would you please raise your right hand? Ms. Getz, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Getz, you may put your hand down. How are you doing, Ms. Getz?
I'm doing good.
I'm doing fine, thanks for asking. Ms. Getz, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And there's a signature at the bottom of this document. Is this your signature?
Yes.
There's some initials online that state you'd like to apply for court-appointed attorney. Are these your initials?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes.
Ms. Getz, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes.
to the best of your knowledge?
Yes, sir.
Ms. Getz, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you the information, you're free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Yes, sir.
Kelly Washington. Ms. Washington, your full name is Kaylee D. Washington. Ms. Washington, would you please raise your right hand? Ms. Washington, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Washington, you may put your hand down. How are you doing, Ms. Washington? I'm doing fine, thanks for asking. Ms. Washington, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature online that's titled Defendant? And are these your initials online that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that's titled Jefferson County Affidavit of Indigence. Recognize this document. On page 2 of this same document, There's a set of initials on a line, well, the signature on a line that's titled defendant's signature, is this your signature? Ms. Washington, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Washington, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Langston Adams. Attorney Adams will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go. And you have a blessed day. Please have a seat in that second chair on the wall. Tyrone Wilson Jr. Mr. Wilson, your full name is Tyrone Dwayne Wilson Jr.
Yes, sir.
Mr. Wilson, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Wilson, you may put your hand down. How are you doing, Mr. Wilson? I'm doing fine, thanks for asking. Mr. Wilson, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature online that's titled defendant?
Yes, sir.
And are these your initials online that state you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indians. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
Okay, Mr. Wilson, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And Mr. Wilson, I read your answers. Based on your answers, meet the eligibility requirements for the person for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Don Boudreaux. Attorney Boudreaux will give information to contact you. You will also be given permission to contact him. And our court reporter, our court coordinator will give you that information. Before she gives you the information, I need to give you some bond conditions. They're going to hand you a document that is titled Standard Bond Conditions in County Court Law Number 2. I'm going to go over this document with you. And the document states Standard Bond Conditions in County Court Law Number 2. Following return of a criminal information in County Court Law Number 2, all bail bonds executed for release of any defendant named here are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing of drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 and 4 does not apply. They do not apply. Condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency political subdivision. Do you understand that condition?
Yes, sir.
And now if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Please have a seat in the first chair and wait for your name to be called. Trinity Sibley. Ms. Sibley, your full name is Trinity Sibley. Okay, Ms. Sibley, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. You may put your hand down. How are you doing, Ms. Sibley? I'm doing fine, thanks for asking, Ms. Sibley. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indians. You recognize this document? On page 2 of the same document, There's a signature above the line that is titled defendant signature. Is this your signature? Mr. Sibley, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Sibley, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court appointed attorney. And the attorney that will be appointed to represent you is Attorney Tom Burbank. Attorney Burbank will give information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go and you have a blessed day. Please have a seat in that first chair, or that second chair on the wall. Michael Livingston. Okay. This is cause number 25 CCCR 0648. Case is style of state of Texas versus Michael Eugene Livingston. Mr. Livingston, is that your full name?
Yes.
Okay, Mr. Livingston, would you please raise your right hand? Mr. Livingston, do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Livingston, you may put your hand down. How are you doing, Mr.
Very
Livingston?
good.
That's
Thank
good.
you.
I'm doing fine. Thanks for asking. Now, Mr. Livingston, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you
Yes.
recognize this document?
Yes,
Is this your signature on the line that's titled defendant?
yes,
Or are these your initials on the line that
Yes.
state you'd like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence.
yes.
Do you recognize this
Yes, I
document?
do.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, it is.
Mr. Livingston, before you signed and initial these documents, did you read the documents?
Yeah.
You understand what you read?
Yeah.
Is everything in these documents true and correct to the best of your knowledge? Hey, Mr. Livingston, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Reuben Cartwright. Mr. Cartwright will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information.
Okay.
Now, before she gives you that information, I need to give you some bond conditions. I believe she's gonna hand you a document that is titled Standard Bond Conditions in County Court Law Number 2. And that document states, following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes. I do.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
I don't drink.
Okay, that's good. All right,
I
now,
keep this.
yeah, that's gonna be your copy.
Okay.
And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location
Okay.
frequented by the alleged victim. Do you understand that condition?
Okay.
Okay, condition number 4 does not apply because that only applies in a DWI case.
Right.
However, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Okay, now if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, you can have a seat in that first chair, Mr. Livingston, and wait for your name to be called. Once your name is called, you go to the window, you'll be free to go, and you have a blessed day. Okay, what happened with, Jefferson County Code Law number 2 is back in session. Court is in session and calls number 25 CCCR 0710. Case of style of state of Texas versus Destin Grant Gillinger. Destin Gillinger was scheduled to be in court this morning at 9 a.m. At about 9 a.m. the court's bailiff called the name of Destin Gillinger at the courthouse door. Destin Gillinger did not answer. A reasonable time has passed to give Destin Gillinger an opportunity to appear in court. The time now is 11:42 a.m. on today's date, May 13th, 2025. Ms. Bailiff, would you please call the name of Destin Gillinger at the courthouse door? Destin Gillinger's name was just called again at the courthouse door. Destin Gillinger did not answer. A reasonable time has passed to give Destin Gillinger an opportunity to appear in court. He is not appearing in court. State, do you have a motion? That motion will be granted. Destin Gillinger bond will be forfeited, and a warrant shall be issued for his arrest. Next case is cause number 25 CCCR 0716. Case of style of state of Texas versus Larry Stoker. Larry Stoker was scheduled to be in court this morning at 9 a.m. At about 9 a.m., court's bailiff called the name of Larry Stoker at the courthouse door. Larry Stoker did not answer. Larry Stoker has not appeared in court since the court has been in session. The time now is 11:43 a.m. on today's date. Ms. Bailiff, would you please call the name of Larry Stoker at the courthouse door?
It's your next court date.
Larry Stoker. Larry.
Yes, sir.
Stoker.
Yes.
Northwest Jordan.
Larry Stoker's name was just called again at the courthouse door. Larry Stoker did not answer. A reasonable time has passed to give Mr. Stoker an opportunity to appear in court. State, do you have a motion?
I think Mr. Palmer.
That motion will be granted. Larry Stoker's bond will be forfeited. Warrant should be issued for his arrest. In cause number 25 CCCR 0716. And this will conclude the calling of the court's arraignment or initial appearance docket on today's date, May 13th, 2025, in County Court at Law number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Prosecutors, you are excused. You are.